Thank you. Thank you for all of you in person for coming out, as well as those of you online. I tend to walk around, so for those of you who are online, you'll just kind of see me sauntering about. So hopefully you can see me up there. Can people see the slides okay? Because I will be relying on the slides. Good? Okay. Okay, so welcome. So this presentation really comes out of a report that I wrote for the British Institute of International and Comparative Law. And let me just say before I get going, for those of you who don't know me, I'm Professor Hassan Ahmad. I'm an assistant professor here at Osgoode Hall Law School. And so as I was saying, this presentation comes out of a report that I wrote for BIICL, a project that has been going on for about, I'd say about 2 years or so now. Overall, it's a comparative project that looks at about, I'd say about 25 or so jurisdictions and the law that concerns corporate climate liability. It doesn't look at any particular area of law. It looks at a country's law kind of writ large, regulatory measures, private law measures, criminal measures, various statutory laws, soft laws, looking at the whole gamut of the legal sphere within a country. So I was tasked to write the report for Canada, and that's where this presentation comes out of. The report itself, if I can get this to function. Hold on. Should this be, yeah, I'll try that. Battery issue. It was working. No? Okay, all right. Yeah, sure. Ah, okay, too bad. All right, next slide. Go ahead. Is it frozen? Oh, there we go. Okay. Oh, there we go. I got it. The clicker's working now. All right. Sorry about that. So the report itself is available online on BIICL's website. You can take a look at it there, as well as the other reports from the various jurisdictions as well. Not relegated to any one particular region in the world. So you have countries from every continent. You have from the global north, the global south, common law, civil law jurisdictions. So that's where you can find the Canada National Report. This talk is being recorded, and I'm happy to share the slides if you don't get that link right now. So the report itself, and therefore my presentation, is kind of broken down into 3 areas. I'm not going to focus in too much on the remedies or the procedures. I'm going to focus more on the causes of action. And even within the causes of action, there's certain ones I'll be focusing on more than others. And it gives you a sense of where I see the viability of the law when it comes to holding corporations accountable for their climate impacts. Not every cause of action is as robust as others. So I'll be focusing on the ones that I at least see as being the more robust ones. So where the report starts with the causes of actions are some of the statutory provisions that we have today. Let me just pause for one moment. It's very interesting that I'm giving this talk today. I got an email from the Ontario Court of Appeal yesterday in a case that I have been involved in, which is Mathor. And the decision in Mathor is going to be released tomorrow. So this comes at an opportune time, but something I might say today might be, I guess, different tomorrow when the decision comes out in Mathor. But these are topics that are very much in front of the courts right now. They're very pertinent and nascent, and legislatures and courts are trying to figure them out as we speak. So where I start off is some of the regulatory regimes that we have, the Canada Environmental Protection Act, which was amended by Bill C5, Bill S5 rather, last year. Canada, until recently, did not have, and it doesn't have explicitly in the charter, a right to a healthy environment. Now, it's debatable what that even means now that it's in the CEPA after the amendment. And it doesn't necessarily result in any kind of liability or accountability, particularly to corporations. But you could argue it's a step forward because we didn't even explicitly, other than some legislation in BC, we didn't federally, at least explicitly acknowledge this right that not only current Canadians, but future Canadians have to a healthy environment. So the CEPA, like many of the other statutory regimes, is a regulatory mechanism. It allows for government agencies to investigate certain allegations of misconduct and take certain enforcement actions. It's not the same as private law liability in a superior court under torts or contracts or other common law principles. So some of the statutory regimes that we have come out of the Paris Agreement and its predecessors, the Kyoto Protocol, the Montreal Protocol, so on and so forth. Now, the Greenhouse Gas Pollution Pricing Act was debated, went all the way up to the Supreme Court, more so on a jurisdictional question. What role can the Canadian government have in carbon pricing? And is it essentially stepping on the shoes of provinces? But again, these are regulatory measures and don't necessarily, I would argue, hit the bottom line of corporations in a way that would actually result in any change in behavior. So let's see what the comment is. 1 second. Why don't we do this? I'll leave questions till the very end. I'm sure we'll have a number of questions as I go through this. Okay. Then we have statutory provisions in human rights codes, both federally and provincially. Human rights law in Canada is largely the law of discrimination. And what comes with that are certain barriers to liability. You have to be able to identify a protected ground. You have to be able to identify an adverse effect. And then you have to be able to connect the two. You have to show that there is discrimination based on a protected ground that had an adverse effect. Now, when it comes to climate change, that can be very difficult. Now, this has been argued both in Mathor in Ontario and also at the federal court in La Rose, the idea that climate change disproportionately affects younger and future generations. So it does have this discriminatory element just by a function of time. It's going to affect, it's being exacerbated, it's exponentially getting worse, and therefore it's going to be affecting younger and future generations more than, essentially more than older people. Again, so you do have the potential and in theory, the ability to argue that climate change and the effects of climate change are discriminatory. But again, you do have to fulfill the various tests for discrimination that are in provincial and federal human rights codes. Okay. Oh, I'm frozen again. All right. All right, okay. Okay, so I mentioned, you might have to stay up here because this is, yeah, thanks. Oh, okay, there we go. All right. So I mentioned the charter, the two primary provisions under the charter in which climate change cases have been brought in the courts is under Section 7 and Section 15. In Mathor, for instance, at least at the lower court level, while the court did find a violation to rights to life, liberty, and security, it didn't find that those were disproportionate or arbitrary. So it didn't affront the principles of fundamental justice. There are a number of other issues in cases like that, one of which being, can the courts even consider the charter in climate change cases, given the widespread effects? And so we'll talk about justiciability a little bit later, but even the ability to consider a charter has been a battle in a number of these cases. And then I mentioned the equality provision, Section 15. So the cases that have been brought to date in Canada have largely been brought against governments, not corporations. There have been cases in the US and the Netherlands and India that have been brought against corporations, but in Canada, we don't have, I'd say, a pure climate change case. And what I mean by that is you can bring a case that concerns judicial review of a pipeline approval, of certain construction projects that indirectly will have an effect on a corporation's contribution to climate change. But we have not had cases directly against corporations saying that they are inordinately contributing to climate change. You do have, for instance, in the Netherlands, you had Milieu Défense, which brought a case against Shell. You have a case in England, in the UK, against the board of directors of Shell, arguing for directors' liability. We don't have anything per se in Canada at this time, but there is the possibility open for something like that. And just to kind of say it now, something I was going to say later, these cases are risky, the law is untested or nascent, and they're very expensive. So the opportunity to do something like that is tricky. You do have to get funding, you do have to get a case like that off the ground, which is very difficult. I'll come back to Toussaint in a moment because I want to mention it with some of the international law mechanisms. We do have certain due diligence legislation in Canada. We have Bill S211 that passed last year, which was due diligence when it comes to forced and child labor. But we do not have mandatory due diligence laws when it comes to climate change or environmental disclosures. So Bill C-62, it says it's stalled. I would argue that it's never really going to pass. People can differ on that, partly because, like other legislation, it has a provision in there that would allow for a private right.
Well, I'm wondering even if we should
case.
postpone the crowd. We've got it. We're missing some. We're missing quite a bit. Quite a few. We're missing now 4 people, I think. 5. Kira, Dilke, Nazia, Megan, and I'm Shanta. Yeah. Yeah, Nazia's on the 3rd.
That's okay.
Yeah.
No worries. Technology. All right. Where was I? Yeah, so you do have Bill S211 that passed. C262, I would argue, will be difficult to pass because of the private right of action in there, the ability to directly siphon profits from corporations under a private law claim. There are a number of other similar types of legislation that have been brought in the past, or rather similar bills that have been brought in the past, amendments to the Federal Courts Act that also would have allowed for corporations to be sued directly under tort law, and those bills never passed either. So what I have found in some of my work is typically when you have these private rights of action or these private causes of action included into draft legislation, they tend to garner a lot more opposition in Parliament, partly because you do have a strong corporate lobby in the background. So you have the Prospectors and Developers Association, you have the Mining Association of Canada, which has been found to lobby hard against this type of legislation. But the reason I include Bill S211 is because there has been some headway made in respect of corporate human rights due diligence, but just not in the context of climate change. Okay. Oh, this technology is not my friend today. All right. Okay, let's keep going. So, all right. Let's try that again. All right. So, where I see some potential for corporate climate liability is really in 2 different avenues. One, in the tort law principles we have today, there's more and more being written about the use of tort law to remedy human rights violations. We have, for instance, my colleague Craig Scott, who wrote about the idea of torture as tort some 2 decades ago. And this has been formulated in many different ways since then to be able to remedy social inequities through private law mechanisms, recognizing that regulatory mechanisms or human rights codes simply don't suffice and don't actually alter the behavior of powerful institutional actors. So you can think about, for instance, indigenous rights litigation, class actions. You can think of prisoners' rights litigation that have used the language of tort law and the common law in order to remedy historical wrongs. And so this it potentially could be another use of that. So within tort law, we'll begin with the idea of public nuisance. This is the public commons that we're looking at: the air we breathe, the water we use, all the natural resources that you can think of that we share. And so therefore, public nuisance would be a rational cause of action. So public nuisance defined as any activity which unreasonably interferes with the public's interest in questions of health, safety, morality, comfort, or convenience. Now, the issue that arises with public nuisance, like many torts, and public nuisance actually hasn't been pled in the cases that have been brought up till now against governments. One of the several issues that you have are being able to connect the parties, being able to connect harmed plaintiffs with corporations or with other institutional actors. The other part of it is you have something in public nuisance, which is called the special injury rule, where you have to be able to show that you have been inordinately harmed by the nuisance itself vis-a-vis others, right? Because we get into ideas of justiciability here that if everybody's been harmed, this is no longer a private cause of action. This is no longer an issue for the courts to undertake. This is better remedied or better addressed through government rather than courts, which are there, and you get issues of standing as well that relate to this. Like courts are there to resolve live disputes. This is still the law that we have today when it comes to standing, that we make certain exceptions for public interest standing, but public interest standing is not for everybody in society. It has to still be for some specifiable group. So public nuisance, while in theory would be a natural cause of action to consider, given that we're talking about the public commons, it comes with a number of barriers. And as I said, it hasn't been pled in the recent youth-led cases before the courts, Mathur and LaRose in particular. So private nuisance, again, private nuisance, like kind of planning and permitting laws that I'll mention in a moment, are indirect ways to combat corporate climate impacts. So you have the Rio Tinto case, for instance, and you have other cases like this where you're arguing against a specific action that a corporation has taken. So in this case, it was erecting a dam that reduced the fish population. And the BC court said that despite the fact that this company had statutory authorization to erect the dam, its impact was beyond what was allowed in statute, which is something very difficult to make out, that you're permitted to do this, and yet what you did went beyond what you were permitted to do. So again, it's a risky kind of claim to bring, but where we have seen some success, and this is the case for claims like Mathur, for instance, where if you impugn a specific act, specific conduct, rather than saying writ large that a company or a government's conduct has contributed to climate change. If you go after a specific act or specific piece of legislation, courts tend to not necessarily accept everything in the claim, but they do tend to be more favorable and to at least allow the claim to continue. So it's less likely that it'll fail for justiciability reasons if you can point to a particular act that the company or a government did. So some of my tort students are in the class. So we've covered ideas of trespass and negligence. Again, I'll start with negligence. Same kind of issues arise. How do you develop arguments around proximity? If climate change affects everybody, then you could argue it affects everybody similarly. And how is it that you are directly proximate to the harm that's taken place? And then this relates to ideas about remoteness, even factual causation. So you do have to meet the common law test, but it's difficult to show that you have been particularly harmed or that you stand in a position to be particularly harmed by a corporation. And then trespass, you can kind of get a sense, and if you know this area of law, the history of a tort like trespass, it was never meant to address issues that arise from climate change, right? The physical invasion of somebody onto somebody else's property is not necessarily well suited to look at toxic emissions, right? And so in toxic tort cases, these are some of the arguments that have been brought up, and courts have repeatedly said these aren't a good fit necessarily because emitting greenhouse gases that affect a large swath of people is not the same as walking onto your neighbor's lawn without consent, right? It's just not there's just not a good fit between the historical trajectory of the common law and the types of harms that we're looking at today. Okay. I won't harp on this too much, but again, you do have some advancements in the law outside of climate change that potentially would allow for liability claims to get some traction. So you have the Dieselgate claim, for instance, that developed the law when it comes to a failure to warn, negligent misrepresentation. Claims like that can be useful in potential corporate climate cases. And then you have equitable principles like unjust enrichment. But again, and I won't focus on this too much, the historical use of unjust enrichment is not necessarily suited for climate liability, especially when you have everybody in society that's being harmed in one way or another from greenhouse gas emissions. Let's see. What time are we at? Okay. Okay. I'll just mention here, so you have the Environnement Jeunesse case in Quebec, which was brought under the Quebec Civil Code. Again, seeking redress for general climate harm. So it was a class action that was brought. And one of the reasons that that Quebec class action was eventually dismissed is that the court said that there was an arbitrary cutoff point that the plaintiffs put of 35 years, meaning if you were 35 years or younger, that you were disproportionately harmed by climate change. The court was critical of this just arbitrary line that the plaintiff class tried to use to formulate the class definition. So it's hard to, again, it's hard to fit our ideas that we have into climate liability because it's more of a nebulous concept. It affects everybody, and it's difficult to make out in court that it affects some people more than others, although factually that has been proven. But to use the common law test that we have and then apply it to a concept like that is very difficult. And then there is an increasing use of ideas around customary international law and treaty law and what's called the doctrine of adoption. So adopting international law principles, again, my colleagues Craig Scott, Robert Wye have written a good deal about this in the past, using the language of international human rights in our common law tests in order to find liability. Many of you know about the case of Nevsun, which was about a Canadian mining company working in Eritrea, where the court, it was on a pleadings motion, albeit, did accept the notion that customary international law can form a common law cause of action. So you can actually use customary international law, which is the general and consistent practice of states, out of a sense of legal obligation. So for those of you who don't have a background in international law, it's essentially a practice that is done out of some sense of obligation. But it was historically a practice done by states. But what the court says in Nevsun is that not only can customary international law form a tort claim, it can form a tort claim against a corporation. Now, agree or disagree, that was a vast change from how the law or how customary international law in domestic courts had developed. You had cases in the US, for instance, that had gone up to the US Supreme Court in Kiobel and Jesner and other cases that had specifically said that customary international law does not apply to corporations. But the way the law, and it's still a nascent area, and Nevsun really hasn't been tested after it came out in 2020. The way the law seems to be developing in Canada is that you can use customary international law as a basis to sue corporations. Now, I mentioned Toussaint before, and I didn't talk about it because I wanted to mention it here. Toussaint, which is a case similar to Nevsun, but not necessarily arguing that customary international law forms a tort claim, but that treaty law forms a tort claim. So there you had the International Covenant on Economic, Social, and Cultural Rights that was being used as a basis for a tort claim when a refugee wasn't provided health care. So it tried to expand Nevsun. It was overturned, if I remember properly, overturned on appeal. But it was the idea, again, that we can use the language of international law in domestic claims. Now, to bring this within the realm of climate change, using the language, and even if they are soft obligations, but using the Paris Agreement, using the UN framework, using the other mechanisms that we have in international climate law, in theory, that language can migrate down to our domestic system to form a claim against corporations. Won't go into this too much. The national instrument, it's really been paused. It was paused for a while. I looked on the Ontario Security Commission's website recently. It still mentions that it's paused. So it hasn't really gone anywhere. The idea of director's liability, I find interesting because it actually starts to question corporate decision-making, and then you get into this whole debate about corporate purpose. What is the purpose of a corporation? Is it just meant to maximize shareholder wealth, or is there a broader kind of stakeholder obligation or a requirement or an obligation that you have to the well-being of non-shareholders, including the environment, including employees? So you have amendments to the Federal Business Corporations Act that came into force some years ago that did include a provision that corporations do have an obligation to the environment. But, and I think this is part of the negotiating process and finalizing a provision like that, because I imagine there was a lobby behind it as well. It doesn't actually create any penalties. It doesn't actually create any liability to corporations that don't necessarily consider the environment. So outside of that context, you do have the potential for a common law claim against directors, against officers. Now, this hasn't been tested in Canada, but it has been tried out in the UK. I'm not exactly sure where this case sits. I think it's stalled for a little bit. I think it's commenced in 2021. A claim that Client Earth brought in the UK against the board of directors of the oil company Shell. Again, an attempt to alter the decision-making process of corporations. Okay, I won't go through all this, but I find planning and permitting laws as one potential avenue, again, an indirect avenue to curtail corporate climate contributions. So the idea of judicial review of certain, whether it's deforestation projects, whether it's pipeline projects, you do have the ability, and there's an inherent right of judicial review that courts have, where indirectly through these individual claims, these individual cases, these individual judicial reviews, courts can mitigate climate impacts. This is not per se claims about climate change, not saying that corporations are being held liable for their climate impacts writ large, but saying that the particular impact, whether it be to the environment, whether it be to indigenous groups or otherwise, the particular impact of this project suffices for it not to go forward. And then finally, I published a paper last year on the public trust doctrine. I find similar to the use of international law in domestic systems, I find the public trust doctrine as one potential avenue that can be used to combat corporate climate impacts. Now, let me explain that. The public trust doctrine, for people, I imagine most people don't know what the public trust doctrine is in this room. It's a historical, it comes out of the Justinian Code, actually. And it was the idea that government hold certain natural resources in trust. Now, the public trust doctrine was historically limited to waterways and waterbeds under navigable water. So it's very limited in what it was used for. Now, in other jurisdictions, particularly India, but also the US, the UK, the public trust doctrine has been argued more generally to say that government holds all natural resources in trust for current and future generations. And therefore, pursuant to the public trust, similar to the international law arguments, the public trust doctrine can form a private cause of action. So you can actually sue a corporation or sue government on the basis that they haven't fulfilled their duty to the environment, that they haven't fulfilled their trust to the public by actually harming the environment. Now, the public trust doctrine was argued in this way in LaRose. It was wholeheartedly turned down by the federal court, saying that this is not the historical use of this doctrine. But like I said, in other jurisdictions, it has gained more traction. And what's called atmospheric trust litigation in the US, which were all these youth-led cases, the basis of them was the public trust doctrine initially, to argue that government holds our natural environment in trust for current and future generations. But in Canada, what I argued in this paper is that the public trust doctrine sits at a crossroads where it can be used in the more expansive way that it's being utilized or trying to be utilized in other jurisdictions, or Canadian courts can look at it the way that the federal court did in LaRose, that this is a historical, equitable principle that only applies to navigable waters. So governments only, hold and trust the right of navigation and nothing else. So you could look at it narrowly, or you could look at it more broadly, that this is a doctrine that actually requires government to protect all natural resources. Okay. Ideas similar to what I mentioned about planning and permitting laws, claims around the duty to consult and accommodate, again, can have indirect effects on climate change. Okay, that's the causes of action. What time am I at? I won't bore you for too long. Just a little bit more though, and I said I'm not going to focus too much on the procedures and evidence, but I think it is important and do play a role, as I've mentioned some of it already. The procedures and the lack thereof do actually play a role in having some claims dismissed or at least challenged. They have in Canada and other jurisdictions as well. Okay. So, like I said, the claims that have been brought to date have been against governments. And they've largely been, when it comes to the pure climate change cases, have been brought by, on behalf of current and future generations. So younger generations and future generations. That's how LaRose and Mathur were both formulated. Again, we haven't had a claim against a Canadian corporation for its climate contributions, just saying that a Canadian corporation has inordinately contributed to the degradation of the natural environment. Although we do have these indirect cases, whether it's the duty to consult, judicial review of specific projects. We've had cases like that, but no kind of writ large climate litigation. These cases where there is some headway to advance the law is these cases do attract a number of interveners, whether it's on either side. There have been more interveners in the cases that have been brought to date on the side of the plaintiffs. So I intervened for an organization in Mathur. There tends to be a whole list, and if these cases go to the Supreme Court, there are going to be a number of interveners, again, on both sides. So you have NGOs, you have industry groups, you have attorneys general. You do have a number of institutional actors that are interested in cases like this. Okay. Okay. I mentioned this previously, that standing is going to be an issue, because if everybody is affected, how can you show that the particular plaintiffs have a cause of action? So if you're an upper year law student or beyond, you will know the idea of public interest standing, that we have this three-part test from the Supreme Court of Canada's decision in Finley. And where the test usually comes down to is there another effective way to remedy this issue outside of the courts or outside of this particular claim? Now, that's looked at more broadly. There's a series of cases after Finley and Downtown East Side and others that have expanded the idea, recognizing that public interest groups are necessary and are really the only avenue at times to bring claims of mass harm into the courts. So we do have this idea of public interest standing, but again, difficult to argue who are you standing on behalf for when it comes to climate change, because so many people are harmed by it. How is one group more harmed than another? Justiciability, it's a related kind of barrier because you have policy-laden issues here, particularly in the types of claims where you're not saying a piece of legislation or a particular act of a corporation or government is causing the harm, but your conduct writ large is causing the harm. The argument comes up that this is better addressed through legislation, through policy measures, not through the courts. And then class actions, I mentioned Environnement Jeunesse, which is a Quebec case that was dismissed based on the fact that the class definition was arbitrarily come upon, setting the age of 35 as the cutoff for being included in the class. The court found to be arbitrary. I'm going to skip over apportionment. So in defenses, it is hard to argue that a company has contributed to climate change when they were initially permitted to do so under statute. So statutory authorization tends to be a defense that's utilized not only in Canada, but in other jurisdictions as well, that there's an unfairness to now bringing a claim when a company is authorized to do something in the first place. I've gone over some of this. I won't go over it again in too much detail, but there are causation concerns, just straight first-year tort law. We use ideas of the but-for test, and if that doesn't work, have you materially contributed to the harm? Now, this presents a number of problems because How can you say that certain corporations contributed to the harm where others didn't? Again, where is the cutoff here, and who are you seeking liability against as opposed to others? Skip over that, and then limitations period, fairly straightforward. Okay, I'm going to finish off the last few minutes on remedies. The cases that have been brought against governments to date, so Mather, LaRose, Environnement Jeunesse, some other cases, haven't necessarily been seeking compensation. So we have pecuniary and non-pecuniary remedies. So because this is a nascent area of law, even getting declaratory relief or potentially an injunction is considered to be a big victory in cases like this. We haven't seen yet, and this might be a function of cases only being brought against the government so far, we haven't seen cases even against government where large sums of compensation are being sought. But in cases against corporations, that is likely going to be the primary remedy to hit their bottom line. Because if you are going to change behavior, and we see this with historical precedent, whether it's the tobacco litigation, pharmaceutical litigation, if you don't hit the profit motive of corporations, you're unlikely to alter corporate behavior. Okay. Okay. So just to finish off, this is a completely nascent area of law we have in Canada right now, because you do not have any particular claims that have been brought against corporations. With that said, claims against governments that are moving through the courts right now will provide some of the language necessary if and when corporate climate cases enter our courts in the future. In addition to that, we have had some headway when it comes to indirect claims, whether it's through planning and permitting laws, whether it's through judicial review, whether it's through the use of international human rights law and its adoption in domestic tort law. So all that entire kind of matrix that's being built up will all be useful if and when corporate climate cases do hit the courts. But again, we don't have anything like that right now. So this is very much a theoretical exercise. But it's good to have thought around it and language around it when cases do start to enter the fray. Okay, let me end there. Thank you very much for your attention, and I welcome your questions. I guess I can, well, there are a number of questions online. How do you want to do this? Okay, why don't I do this? I'll read, there's a number of questions online. I'll read the first one, and then I can go to the room if anybody has a question here. So Carrie, thanks for your question. Does this relate to the defense of the federal government had in response to providing clean water to native Indian reserves? I know that's been an issue recently. Are we talking about, and Carrie, if you want to specify your question, are we talking about statutory authorization, or are we talking about issues of causation, or not really sure what that's referring to? Oh, okay. That's fine. Oh, you have another question. Okay, what about the rights of nature movement? What are the chances it will be adopted by the UN and Canada? So there are a number of cases in other jurisdictions where legal personality has been given to natural resources, to rivers, to oceans, in order to argue that those entities are harmed, are plaintiffs that can bring a claim in their own name. I think that's what's being asked. I don't know where that movement stands in Canada right now, but there haven't been any, like I said, there haven't been any corporate climate cases brought to date, and there particularly haven't been, at least that I know of, any kind of cases where you do provide legal personality to a natural resource in order to claim that it's been harmed by climate change. So if corporate climate cases are nascent, the rights of nature movement is extraordinarily nascent, and I don't foresee that really entering the fray anytime soon. Anybody in the room have any questions? Yeah, Anthony.
Thanks for the presentation. Legal framework. I think I have two questions around the issue of like, the nature of human generation. And the first maybe is just kind of a question about how this is being framed.
Right.
On the discrimination side.
Yeah.
First, so is the thought that human generations are ground of discrimination, like an age-based ground, so it's like kids and
Yeah.
or is it an entirely new ground, or I guess that can't be argued under human rights legislation, but it can be argued. So I'm curious how that gets.
Yeah.
And that sort of also had a question that to private law standing.
Mm-hmm.
So I just wondered if they discourse around that, so that there are family law
Yeah. Sure. Yeah. Right. Right.
Of course, we have litigation guardian rules.
Yep.
Kids who are litigation guardians step into them.
Yeah.
But I'm wondering about more
Yeah.
which so I think is
Yeah. So, no, thank you for those. The Section 15, the equality claim, that's, I don't know off the top of my head whether it was just a enumerated ground of age or whether it was based on an analogous ground. But Section 15 was pled in both Mathor and LaRose, received more traction in Mathor, not necessarily because the claim was, no, Section 15 is Section 15 in both cases, but Mathor gained some more support from the Ontario courts because it looked at a particular piece of legislation. So arguing that something is discriminatory gets you a little bit further if you can say a certain conduct or a certain action was discriminatory as opposed to your conduct writ large. But I don't exactly know if it was an analogous ground or an enumerated ground they brought. The private law standing, again, somewhat theoretical because the cases that have been brought as mass tort claims where not even necessarily class actions. It is, you have some class actions and then you have just mass tort claims where everybody has standing. So you'll get a select group of, and I'm talking about in Canada and in other common law jurisdictions, you'll have cases where, it'll be brought by a dozen or so youth claimants, all of whom have standing. Or you will have class actions. I come back to when it comes to standing on behalf of a broader population, I think there's going to be difficulties because, again, how do you show that you have been inordinately harmed vis-a-vis everybody else? And then the other part of it is, we require a live issue. Have you been harmed already? Have you been harmed more than others already? Right? So the law that we have on standing, and even in the three-part Finley test, you have to be able to show some live dispute. And so this is a perspective, and this is some of the challenges that the plaintiffs faced in Mathor and LaRose, that some of these concerns are in the future. So there's not necessarily, even with that, both of those cases got over the standing issue. But that is a concern, that you have this prospective harm as opposed to the immediate harm. And then again, I think standing is tied to justiciability as well, that not only is it difficult to show that these particular plaintiffs were harmed, but isn't climate change something that harms everybody, and therefore the courts are not well suited to address this? And what some courts have said, so if you look at, for instance, Bancroft and other kind of non-climate related cases that kind of touch on this as well in environmental issues, is that, and this comes out in the US jurisprudence as well, courts have a particular role to afford standing or to overcome justiciability arguments because the political branches of government are not acting, right? Because you don't have legislation, because you don't have private law causes of action in statutes, it's all the more reason for courts to step up. So with all that said, I think standing is going to continue to be an issue. In addition to all the, the causation, the proximity, I think they all come hand in hand. Yeah. So a claim against the corporation is not necessarily challenging the decision-making process of the corporation. It's looking at the effects that the corporation's operations have had on the environment or on third parties, right? The Client Earth case is about how Shell's board of directors are prioritizing their decision-making, right? As opposed to making decisions for the broader good, the public good or the good of the environment, they're prioritizing what is traditionally considered to be the corporate, post-Milton Friedman, the idea of the corporate purpose, which is how do we maximize shareholder wealth, irrespective. Well, so that proximity would be an issue when you're looking at a claim that your decisions have affected the environment, because you could argue we act in the best interest of shareholders. That's who we're proximate to, right? So you have derivative actions, you have oppression remedy for things like that as well. But a third-party claim, right? This is part of the concern in a case like Client Earth, is there a duty in the first place that the board of directors has to the environment and those who are affected, not non-shareholders who are affected by their decisions? So, how can academic research regarding the inequitable impacts of climate change most effectively support, I think that's legal actions? So I wrote the paper on the public trust doctrine, particularly because I see this as an area of law that's very nascent, and it can go one of many different ways, whether it's claims against governments or claims against corporations. And this really brings into the fore the role of courts vis-a-vis the other branches of government. So courts can see themselves, and this is a lot of what I've written about, courts can see themselves in the kind of, in Blackstone's kind of, view as these oracles who kind of solve these big problems and step in when government is not doing its job, right? So this is Habermas's argument as well, this idea of co-originality. When one branch of government is not functioning the way it should and doing what it should, the other branches can step up. And the other view is the more conservative view that courts are mere interpreters of the law, that they follow suit with what the law is and has been legislated. So I find climate change to be one of those issues where particularly academic research is useful when we look at, one, the role of courts and how courts function vis-a-vis the other branches of government. And then two, there are particular doctrines that I think can be very useful, whether it's public nuisance, the public trust doctrine, or just the general idea of the evolution of the common law, the expansive nature of the common law, that we can take historical ideas, whether, we can take tort law as an example, we can take historical ideas and apply them to new challenges. I think that's where academic research is particularly relevant at this point. I can go back to the room. Yep. Right. Yep. So just be careful. The public trust doctrine doesn't necessarily advocate that one government has sole control, right? It's just that government as representative of the people, and you can interpret that how you want, of some people, all people, has some authority over natural resources. Now, what's interesting is if you look at it that way, governments can be defendants, they can also be plaintiffs against corporations. So we have the Canfor case, 2004, I think, the decision of the Supreme Court, where the government brought a claim against Canforest pursuant to a forest fire. And it was the first time, and it wasn't the public trust doctrine per se, but it really was, that the Supreme Court was considering that the government, as the representative of the people, has this parens patriae representation, and therefore, pursuant to the public trust doctrine, because it has authority over natural resources, when natural resources are harmed, it can go after the parties that impacted those resources, right? So again, those cases haven't necessarily been brought, but there is that idea as well, is that government as the protector of natural resources, you can sue the government when the allegation is brought that it hasn't sufficiently protected those resources, but then the government can sue private actors as well when the argument is that they haven't protected those resources. But all in all, I do see the public trust doctrine depending, and this is why I wrote that paper, because I think it is at a crossroads. And I would rather, the argument I made in the paper was I'd rather see Canadian law move to the more expansive iteration of the doctrine. Anything online? Oh, sure, okay. Given this broad overview, can we shift the discussion to Earth systems rather than climate change? Curious, what about provincial and federal government responsibility to provide adequate education, information, and fit the purpose science-based programs to local communities to support warming with warning systems in earthquake-prone locations? Interest is in provincial government responsibility to specific populations within a jurisdiction. Okay. So obviously I don't know about all those topics, and I'll stick to climate change to an extent, but one thing I will say, again, I think the use of international law, of international human rights, and the language that has come out of the idea of customary international law and treaty law can be useful in domestic claims. So for instance, that's why I had a case like Toussaint in there. The idea around the right to health and healthcare, irrespective of citizenship or immigration status, that was at issue in Toussaint. So similarly, when we look at these other topics outside of climate change, you can use the language that's been formulated in international law instruments and then try to bring them into the domestic framework. This is what was done in Nevson. But again, this area of law is in flux, and courts have the ability to take the more expansive approach to allow for some of this language to come into the domestic framework, or it can take the more reticent or conservative approach, and I don't know which way it's going to go. I can move back to the room if there's anybody else. Yep. Right. Yeah. 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 Yep. Let me put it this way. I want to remain optimistic. I'm not necessarily confident, and let me tell you why. This is not the first issue that's arisen where the courts are being used as a strategic tool to impact social change. So you can go back to the civil rights era, you can go back to tobacco litigation, pharmaceutical litigation, Me Too litigation, indigenous rights litigation. The argument I've made is courts serve a number of functions, and one of them is to provide a remedy to claimants. But other functions they can serve are to bring awareness around a topic where it didn't exist before. So, you know, even if we look at other areas like pharmaceutical litigation, you know, the law necessarily has not been successful or moved forward in any serious way, right? But it's brought awareness around these issues in a way that government or even the public was not able to, right? If you look at, you know, I use this example, and I don't think this is controversial at all. I think it's factual, that issues around residential schools, issues around Indigenous rights, although they were known in certain sectors, really came out into the public eye post 2006, 2008. Well, okay, if you add up the timeline, why is that? Because you started to have court cases commence that got into the media. And so I do think the courts have a role outside of just their decisions where they can be useful. But I agree with you that the law hasn't necessarily moved forward. People thought that Nevson would be a watershed moment. That's debatable. It's been 4 years, and 4 years is not a long time in the history of the common law, but you really haven't seen much movement, partly because these are very risky cases. They're expensive. And the other part of it is you're representing marginalized groups at times. So it just doesn't have that momentum that other types of cases will have. So, but I do remain optimistic. I can go. Yeah, global warming. Do you think Arctic waters land require protection under new regulations, or should existing laws address these issues? I don't have a good answer to that because I don't know that area well enough. Again, coming back to what was said previously, I do think the courts have a role, particularly when multilateral efforts. So if we look at the Arctic ice cap, if we look, you know, multilateral efforts have been minimally effective. Individual government regulation has been minimally effective. And I think in that absence, I'm not saying courts are the solution. I'm not saying they're the best solution. I'm not saying they're the only or the best avenue, but they ought to become an avenue when the other branches of government and when governments together have been unable to come to effective solutions. Yeah. 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 You know, I don't have a great answer to that. We've made certain exceptions to limitations period, whether, you know, issues of sexual assault or limitations period will toll at times for capacity reasons. We will have a better understanding if limitations periods are actually challenged or the issue is actually brought up in cases. The cases that have come to court so far, for whatever reason, defendants haven't tended to focus on the limitations aspect of it. And again, this goes back to the question that was asked before, partly because the way these arguments are framed are the prospective harm, right? As opposed to the past harm. So maybe that's why limitations haven't been at the forefront of the arguments that have been brought. But yeah, and we won't know until the dispute becomes live in courts. Okay, I'll take, why don't I do this? Because I'm just looking at the time. I'll take one more online, and if anybody else has one in person. Let me do the last one. Can environmental law be used in these courts to address the harms of climate change on a global scale, or if that's too broad? Okay, so this was an argument brought up in Mathur that you know, climate change is borderless. It stems across the globe, and there are, let's say, you know, foreign actors that impact climate change in Canada. There are domestic actors that impact climate change elsewhere. So this is not going to necessarily answer the question because I don't know, and I don't think courts would be ready and willing to consider global climate impacts. But what the court said in Mathur in particular is because Canadian institutions, the Ontario government in that case, because institutions in Canada have effects outside of Canada, is not a reason for us not to hear these cases, right? So just because there is a global impact, just because climate change is borderless, is essentially an argument to evade liability. Just because something is transnational is not a reason for courts not to consider it. So the transnational nature doesn't necessarily affect the ability of courts to hear these types of cases, but there's a jurisdictional issue here. Harm outside of Canada by non-Canadian actors, so what's called a foreign cubed case, where the parties and the harm take place outside of Canada, so you require universal jurisdiction. Those are the types of cases that courts tend to dismiss on jurisdictional grounds. Any last, yeah. Yep. Yep. Well, firstly, so we were talking about is horizontal migration, the idea that you can use charter values or the language of the charter and import that into the private law. Now with remedies, you don't necessarily need to do that because we have private law remedies already. You don't need to take the public law remedies because there's a jurisprudence around private law remedies. But more broadly, about the idea of charter values, yeah, this is something that could potentially come up. I think that was my point when I was saying that the language of cases like Mathur and LaRose can be helpful. When we look at ideas of discrimination, ideas of equality, ideas of the right to life, that can be imported into the private law. Now this is all speculative because we haven't had cases like this yet, but I think that work that's being done now on the government side of things can eventually be useful when it comes to the private side. And if you look at a case like Nevson, that's really what happened. You had a historical trajectory, both in Canada and other jurisdictions, of building up the language of international human rights and its use in Canadian courts. And so when Nevson comes to the Supreme Court, not only does the court allow for a private cause of action under customary international law, it imputes that onto corporations. And so if we didn't have that language build up in the public law sphere in the years and decades prior to that, maybe Nevson would have ended up a different way. And I think it's going to be this, arguably, could be the same when we look at corporate climate liability. Okay, I'm just cognizant of the time, and I know people have places to go. I'm happy to end it there. Again, thank you very much for coming. For those of you in person, I'll stick around if you want to chat. Thanks.